Our top focus on headlines tonight. The Supreme Court panel formed to probe charges of sexual harassment has let off Justice Ganguly with just a rap. The panel has released a statement and I quote from it now. We have carefully scrutinized a statement of the victim and the statement of A.K. Ganguly. It appears to the committee that the victim had visited the hotel where Justice Ganguly was staying to assist him in his work. This fact is not denied by Justice Ganguly in his statement. Further, the committee is of the considered view that the statement of the victim, both written and oral, prima facie discloses an act of unwelcome. Within quotes, it puts unwelcome verbal, non-verbal conduct of sexual nature by Justice Ganguly with her in the room in the hotel approximately between 8 p.m. and 10:30 p.m. Considering the fact that the said intern was not an intern on the roll of the Supreme Court and that the concerned judge had already demitted office on account of superannuation on the date of the incident, no further follow-up action is required by the court. The SC panel literally letting Justice Ganguly off the hook here. For more, let's get in a word from our correspondent Jaskirat Singh Bawa, who's joining us from our newsroom this evening. Jaskirat, essentially what the Supreme Court panel is saying is that the accused and the victim can now follow up this allegation with the police complaint, but the Supreme Court will not act in this matter, considering that Justice Ganguly had already retired and that this intern wasn't on the payrolls of the court.
The findings of the panel, which are actually a part of the Chief Justice of India's note which has been made public, has recognized the fact that there were some moves or advances made which were sexual in nature and that they were unwelcome. This is as far as the extract of the panel's finding go. The Chief Justice has added his own note to that particular finding, suggesting that since the intern was not on the rolls, and this is not a payrolls, this is on the rolls in the sense that all interns of the Supreme Court judges are registered and they have to go through a due process, and they're all registered interns of Supreme Court judges because they're always all the more handling very sensitive cases. So in that manner, she was not an intern of a serving Supreme Court judge. Also, the fact that Justice A.K. Ganguly had already retired and was not a part of the Supreme Court infrastructure, the administration, or a part of the Supreme Court at that given moment when the instance took place. So the Chief Justice of India has noted that given these circumstances, though the committee has found and in a way has disapproved, given its disapproval about his act, the Chief Justice of India has appended that note with the exact line suggesting that no further action is required by the court. Now, there are two ways of looking at this. One way would, of course, be the fact that why couldn't the Supreme Court, in the light of the fact that they have themselves found some prima facie incident of having taken place, could have taken suo motu cognizance, or perhaps just directed the police to take action. But at the same time, there is another school of thought that says that everyone is equal in the eyes of law. So if in a regular case of somebody harassing someone sexually, the Supreme Court doesn't direct the police, but the police themselves take cognizance of that action, then why should an exception be made for Justice Ganguly? Why not the police? And there are two complaints pending over here, remind the viewers. Right. One is with Delhi police and one is with Calcutta police. With the Delhi police, there was a third-party complaint filed by Professor S.N. Singh, the former DU Law Faculty Dean, along with another retired IAS officer. And with Calcutta, there is a complaint filed by an NGO. So the police is completely free to take cognizance of those complaints and this committee's finding and take the investigation forward. So basically, the Supreme Court putting the ball in the court of the victim and the police. Let's also get in a word from Kalyan Banerjee, TMC MP, who's joining us on the phone line. Thanks so much for speaking to Headlines today. Mr. Banerjee, your first reaction, the Supreme Court not taking action against Justice Ganguly. Do you think he should at least step down from the position of the chairman of the West Bengal Human Rights Commission, considering the fact that the panel has held him guilty?
Thank you. That I read the report which has been sent to me. I have seen it. It appears that the Supreme Court has prima facie, this is an administrative, you must remember first that it is an administrative committee. The prima facie discloses an act of unwelcome behavior, within bracket unwelcome verbal stroke non-verbal conduct of sexual
So
nature.
Basically the Supreme Court has acknowledged that this is a case of sexual harassment. Mr. Banerjee, my question to you is your government going to act against Justice Ganguly?
My government has no jurisdiction to take.
But there is a case that has been registered with the Kolkata police as well.
Will you kindly hear me?
Yes, please go
ahead. If you have put a question, kindly hear me. Under the Human Rights Commission Act, state government has no power to remove him. The chairman of the Human Rights Commission can be removed only by way of impeachment in the parliament, in both the House, Lok Sabha and Rajya Sabha. Therefore, the government has no power to take steps. Since it is a Supreme Court has half-heartedly left the matter in this case. If this is the finding of the Supreme Court, then the Supreme Court should have sent his report to at least to the police station for taking appropriate steps.
All right, but Mr. Banerjee, but we're being told that a case has been registered with the Kolkata police as well. Are you going to ask your police to take action on that complaint?
Please listen, Kolkata police has no jurisdiction because the alleged offence was committed at Delhi. This offence has been committed at Delhi. Therefore, Calcutta police has no jurisdiction. It is the Delhi police and the jurisdiction to proceed in this matter. And also the complaints were lodged before the Supreme Court and in an administrative side. Therefore, this administrative side also falls within the jurisdiction of the
All right, Mr. Banerjee, what is your party's stand as far as this case of sexual harassment is concerned?
So far, my party is concerned in respect of general sexual harassment.
No, not about general sexual harassment. This particular case of sexual harassment, because we've also seen...
Madam, I have already last 5 days I am going on saying that Mr. Justice Ganguly should resign first from the chairman of the Human Rights Commission.
Okay.
That is the first time immediately after the things had come out, from the report was disclosed last few days back, I was the first one who said Justice Ganguly should come out, because there are two reasons for that. One reason is that unless he resigns, the victim girl may feel that because of his influence the case is not properly investigated. He is influencing. You have to do justice to the victim girl also. Secondly, not only the Caesar's wife, Caesar should be above all suspicion. If a person cannot give respect to the women itself, how can he be the custodian of the human rights?
Right. Mr. Banerjee, thanks so much. Stay on with us. We also have noted lawyer Abha Singh joining us on the phone line from Mumbai. Abha Singh, there are so many cases in which the Supreme Court takes suo motu cognizance, yet when one of its judges is involved, it says that on a technicality, it can't take action against the judge.
Now that the Supreme Court panel has indicted Justice Ganguly, the registrar should have gone to the police station and registered an FIR. But since they have not done it, the Delhi police should suo motu take cognizance, because now offence is made under 509 IPC and also 354, that is outraging the modesty of a woman. The police, and in a cognizable offence, no locus standi is required. The police can suo motu take cognizance, and the police should immediately register an FIR under 154.
And Ms. Abha Singh, the Supreme Court could have also recommended that Justice Ganguly step down from the position of chairman of the West Bengal Human Rights Commission.
That, of course, should have been the way. The registrar should have gone and registered an FIR. But now that he is indicted, it should be in the interest of things that he steps down immediately. And in case he is not stepping down, he should be placed under suspension by the respective authority, because being on such a premier post, he should not only appear to be honest, but he should not be honest, he should appear to be honest. And these are Supreme Court guidelines. When UP Chief Secretary was indicted, or the recent case of CBC Chairman Commissioner Thomas, they both stepped down. So Justice Ganguly has to step down, and if he doesn't, he should be placed under suspension, because the SC panel has now indicted him. And in fairness of the fair, when it's a cognizable offence, both offences are cognizable but bailable. So he can apply for bail, but it should be action should be taken.
Abha Singh, I also want to ask you, considering the fact that in this particular case of sexual harassment, a judge is involved, constitutional agencies have been dragging their feet. It also exposes double standards of our society.
See, till the time it was accusations, one could have said, because the girl has not come forward to register an FIR. But now when the charges stand proved, they are indicted, then of course, if the police is not taking action, I will definitely say that Delhi police is dragging its feet. It has to now, it's a cognizable offence. They are bound to take a suo motu cognizance under 154 of the CRPC and register a FIR as early as today itself.
All right, Abha Singh, thanks so much for speaking to Headlines today. Is the Supreme Court panel shying away from taking action against Justice Ganguly? So should more recommendations have been made to the National Human Rights Commission to remove Justice Ganguly from the position of chairman of the West Bengal Human Rights Commission? Here are some reactions.
Two things are very clear. A cognizable offence prima facie has been committed under Section 354 of the unamended Indian Penal Code. And I think the law should take its own course. We all know that the police have the power to register a suo motu complaint or an FIR, and that's one course of action. The other, of course, is that I do think that having regard to the position that he holds, he should forthwith step down and resign. This is the only thing that will actually restore the credibility of institutions which are meant to protect the rights of women, including human rights. So I earnestly hope that he steps down. I would call upon him to step down.
The Supreme Court panel formed to probe charges of sexual harassment has let off Justice Ganguly with just a rap. The panel has released a statement, and I quote from it: "We have carefully scrutinized the statement of the victim and the statement of Justice A.K. Ganguly. It appears to the committee that the victim had visited the hotel where Justice Ganguly was staying to assist him in his work. This fact is not denied by Justice Ganguly in his statement. Further, the committee is of the considered view that the statement of victim, both written and oral, prima facie discloses an act of unwelcome behavior by Justice Ganguly with her in the room in the hotel approximately between 8 p.m. and 10:30 p.m. Considering the fact that the said intern was not an intern on the roll of the Supreme Court and that the concerned judge had already demitted office on account of superannuation on the date of the incident, no further follow-up action is required by this court." Now, the question really being asked at this point is the Supreme Court panel shying away from taking action against Justice Ganguly? Let's listen to some of the initial reactions that came in.
Two things are very clear. A cognizable offence prima facie has been committed under Section 354 of the unamended Indian Penal Code. And I think the law should take its own course. We all know that the police have the power to register a suo motu complaint or an FIR, and that's one course of action. The other, of course, is that I do think that having regard to the position that he holds, he should forthwith step down and resign. This is the only thing that will actually restore the credibility of institutions which are meant to protect the rights of women, including human rights. So I earnestly hope that he steps down. I would call upon him to step down.
Statesmanship of the Chief Justice, his institutional integrity has paid off. You today see a court, a committee of a court, believing the evidence of a young lady and few other witnesses over the evidence of one of their own, proving to the world that even where that institution is concerned, they abide by the faith that however high you may be, the law is above you. It is a great boost to the morale and courage of women that doesn't matter however high the person is who misbehaves with you. If you have the courage to fight, the Supreme Court will be on your side. So I think it's a great thing. Now, legally, what they have done is the right thing. She unfortunately was not on the rolls when this happened. He is no longer a judge. So institutionally, they can do nothing beyond condemn him. And I don't think you need strong adjectives to condemn a person. Sometimes stating the truth itself is a huge condemnation. And as far as the law is concerned, the Delhi police should not take the law to its logical course.
See, frankly speaking, in this matter where the complaint discloses the commission of a cognizable offence, the FIR should have been registered by the Delhi police suo motu. You don't need a sanction of the Supreme Court in this matter.
Right.
And I think that the Supreme Court also committed a mistake in constituting a committee, because the act by a judge was not done in the precincts of the Supreme Court. It is after retirement, done in a hotel premises, which they are not concerned.
Right.
First of all, they should not have constituted a committee. Looking otherwise also, a prima facie finding given by Supreme Court, either way, for or against, would have jeopardized the case of intern and or would have jeopardized the case of a judge. So I feel that that prima facie finding ought not to have been given by the judge. The best thing was that the cognizable offence was made out the moment statement was made by the intern. The case should have been registered and should have been tried like an ordinary citizen is tried. He is denying the allegation. That doesn't make a difference. Police has to go ahead, register a case and do the investigation.
Sugata Roy, TMC MP, is joining us from Kolkata. Also, Jaskirat is from the Headlines Today newsroom joining us here on Newsnight. Let me come to you first, Jaskirat. Clearly, as far as the mandate of this probe committee was concerned, has been fulfilled in the sense that this was looking into administrative derailment and also at the charges. But clearly, at the end of the day, the Supreme Court probe panel has pretty much washed its hands of the very nature of this crime.
Well, there's two schools of thought over here. Now, even the staunchest of critics within the legal fraternity, as when last week Justice Ganguly's name had actually come out, had said that he should step down. His name has come out. Even they are suggesting that what the Supreme Court has done right now has actually treated all accused in the eyes of law as equal. So since any other individual citizen who is accused of sexual harassment doesn't require a judicial activism for the Supreme Court of India or the Chief Justice of India to direct the police authorities to take action against him, in a similar fashion, Mr. A.K. Ganguly, ex-Supreme Court judge, should face actions against him as a citizen of India. There is a registered police complaint pending both in Calcutta and in Delhi. So it is basically throwing the ball in the police's court to take this forward.
Just hold on, we're getting some breaking news coming in. And breaking news coming in, Sushma Swaraj, who has been leading the charge against Justice A.K. Ganguly and saying that he must step down as the chairman of the West Bengal Human Rights Commission, has now tweeted saying that since the SC panel has indicted Justice Ganguly for his unwelcome behavior, he should further step down. His continuation as chairman of the West Bengal Human Rights Commission is most unwelcome. Sugata Roy, MP of the Trinamool Congress, is also with us from Kolkata. Mr. Roy, the Trinamool Congress has also been demanding that Justice A.K. Ganguly should step down. Don't you think that the Supreme Court should have also directed the police to file an FIR and take forward the criminal proceedings in this case?
I have seen the report of the three-judge panel headed by Justice Ranjana Desai, which was set up by the Supreme Court Chief Justice. It has called Justice Ganguly's act as an unwelcome act, and thus it has endorsed the complaint made by the law intern. But the Supreme Court panel has taken refuge behind technicalities in not recommending an action against Justice Ganguly. The Supreme Court panel has also not been correct in naming the girl in their report. However, considering the gravity of the charge and the fact that the charge was upheld by the Supreme Court panel, Justice Ganguly should forthright resign from the chairmanship of West Bengal Human Rights Commission to save his own face and to save the prestige of the high office he has held, because his unwelcome act has brought down the prestige of the judiciary and the entire legal fraternity. I think also that at this stage the Delhi police can and should take suo motu action by lodging a FIR against Justice Ganguly. Otherwise, the Delhi High Court, on receiving a PIL, can also order taking suo motu action by lodging a FIR against Justice Ganguly.
Okay, Mr. Roy, stay on with us. Jaskirat, you were talking about the two schools of thought within the legal fraternity. Now, questions have been asked right from the time the blog by the law intern became public, that as per the very nature of the crime and the charges that had been made, the gravity of the crime, that a suo motu FIR should have been filed.
Well, that is correct, and we have seen a similar instance take place in a crime of even higher gravity in nature, but of course on similar lines which happened in the Tehelka case. So comparisons were being drawn in the legal fraternity itself. I'm only reflecting on the thoughts of the Supreme Court high lawyers and the judges. Let's just go back to as to why the committee was even formed. It was formed, and I very vividly remember the Chief Justice of India saying that this is a committee that has been formed and they need to look into the veracity of the allegation. That's the first line that was said. And then said that we need to come out with the name of the person or the perpetrator in this, because a lot of rumors and gossips were doing their round and a lot of names were being thrown up and a lot of reputations were at stake. Now, as far as the police complaint and the suo motu cognizance of the police complaint is concerned, a complaint is already pending with the Delhi police. There was an NGO in Calcutta also which had filed a complaint with the Calcutta police. Now it is honestly really in the ball of in the court. The ball is in the court of the police authorities as to how they take this forward. The real clincher over here would be if the victim actually comes forward and agrees to record her statement with the magistrate or the police authorities, because that will add the maximum traction to the police complaint. In the absence of that complaint, and as we have already learned from initial reports when the victim had presented herself to the Supreme Court panel, that she is not inclined towards a criminal charge or a criminal case complaint against the perpetrator. With the absence of that statement with the police authorities, they may inevitably have to file a closure report. So that will have to remain to be seen as to whether or not she will come forward and initiate a criminal complaint.
Pramila Nasargi, senior lawyer, is also joining us on the phone line. There are two schools of thought, Pramila Nasargi. One saying that perhaps the Supreme Court could have directed the police to take action against Justice Ganguly, and the other saying that this in itself is a precedent as far as the judiciary is concerned, and the action that has been taken and the results of the probe committee report are in itself historic. Which school of thought do you belong to?
See, I belong to third class. I only said the moment the matter came to light, the police should have taken cognizance of it and they should have registered the case by themselves. Leave that as it may. The Supreme Court, when it issued the complaint, it should have, instead of asking for a committee report, it also should have reported the matter. Now that they are having a report by themselves and they have all the material, they should have immediately forwarded the matter to the police and asked them to take law into its own. But they have not done it. But now, as on today, there is already an FIR filed. Whether FIR is filed by individual or by the Supreme Court or by any other person, it serves two purposes. Let them go ahead with the case and investigate. Now, whether it is Asaram or Islam or Tarun Tejpal or Supreme Court judge, law must be same so far as
Stay on with us. We also have Vikas Singh, the former Additional Solicitor General, who's joining us on the phone line. Mr. Singh, clearly as far as the judiciary is concerned, and we've been getting a lot of opinion from the legal fraternity, that this in every sense of the word has set a precedent. It has for the judiciary also been a test case.
Yeah, of course, according to me, this is the first time this kind of an allegation has been made. And probably that is why the Chief Justice of India, in order to, sort of give an impression that the judiciary is not wanting to cover this kind of an allegation under the carpet, set up this committee. But I think that the formation of the committee was a little, sort of without application of mind, in the sense that if it's the commission of a cognizable offence, then ultimately it has to be investigated by the police. And the police has to decide whether the offence has been committed or not. The committee's report will not in any manner either advance the case of the intern before the police or, sort of harm her case. So, really speaking, it has not, the judicial process has not taken, properly, in my view, by the formation of the committee. And now, after the committee's report has come, now they say that he's a retired judge and accordingly we can't do anything about it. So the whole exercise now appears to be in futility, according to me.
Very interesting that you say that, because a number of people have raised questions about first the formation of this committee and the amount of time that it has taken for it to finally come out with its probe report and the final analysis or the final results of it, where they've said that clearly as far as Justice Ganguly was concerned, there was unwelcome behavior. Don't you think a lot of time has also been lost, that an FIR should have been lodged immediately?
That's exactly what I said, because yes. I said that if it has been, the committee formation itself was without proper application of mind. That's what I said. So if it had not been formed, probably by now the FIR would have, gone much ahead and would have examined, the police officers would have examined the complainant, the accused, and would have taken a view by now. I'm told even today there is no formal FIR. There is a complaint to the police, one in Delhi, one in Calcutta, but there is no formal FIR registered even till today. So this, I think, because of the formation of this committee, this legal process has been delayed by at least 2 to 3 weeks.
Do you think then, and if I might overstep the line at this point, do you think that the formation of this committee was just to delay the inevitable? Because as it is, the committee was only looking at administrative details, and finally by the end of it, it came down to technicality that the justice was no longer on the rolls. He had superannuated by then, and neither was the law intern.
No, I will not say that it was meant to derail. That was definitely not the intention. I'm sure the Honorable Chief Justice had very pious intention in mind of, sort of trying to get to the truth. But it was without application of mind, in the sense that he did not realize that this committee, even if report comes which way, will have no jurisdiction to decide the course of action as far as the law has to take. So that way it was a little... But I will not say that it was meant to delay. I say that it was without application of mind. If we had probably thought of all that before forming the committee, if you recall, this was all done while mentioning the matter before the Chief Justice. Firstly at 10:30 and then again at 2 p.m. 10:30, some PIL petitioner mentioned, 2 p.m. I believe the Attorney General mentioned. So it is actually in that, whole the 10:30 to 1, he must have been hearing matters, the Chief Justice. So during the lunchtime, he took a call that he will form this committee. So probably he didn't have enough time to actually think about the effect of forming this committee and how this committee, how legal and how valid the findings of this committee will be for the judicial course to take in the matter in the long run. So that's why probably this has happened. But this was definitely not meant to delay the whole thing. I'm sure about that.
Mr. Vikas Singh, for speaking to Newsnight. Thank you so much. Lots more reactions coming in. Let's listen in.
For Supreme Court committee, the committee which was constituted, they have found prima facie that the unwelcome behavior has been shown. Now point is this here, the Supreme Court knows, Supreme Court knew that he was a retired judge, that lady was an intern. They don't have any other jurisdiction to do it. However, since it was a public domain, the complaint, Supreme Court has constituted a committee, the report has come, which shows that the Justice Ganguly has committed certain offences, which is not accepted. Nobody can welcome it. Therefore, now two things are required to be done. That the Delhi police should start criminal case against him immediately. Because all these discussion documents, everything are public domain. Delhi police should start criminal case. Although there was an FIR before at Calcutta.
These are very delicate matters. I don't even know what the girl has told the court. Unless these things become public, how am I to... And I must tell you that Ganguly is my friend. And I don't sit in judgment over my friends without even hearing my friend.
Mr. Subrata Roy is still with us from Kolkata, TMC MP. Mr. Roy, there were many eminent jurists who were backing Justice A.K. Ganguly primarily on the fact that perhaps this one case might set a very dangerous precedent. And dangerous precedent in the sense that the evidence in this case was just prima facie an allegation made.
Yes, it was a clear case of sexual harassment. It was misuse of the position that Justice Ganguly held, and it was an unwelcome act, as the committee has said. So the main question now before everybody is whether Justice Ganguly should continue as chairman of the West Bengal Human Rights Commission for a day. 2, whether the Delhi police should immediately lodge a FIR against him suo motu. My answer to both these questions is yes. And I do not know why this delay took place in the case of Justice Ganguly. It seems to me that the Supreme Court panel, of course, they have softness for a former Supreme Court judge, and that's why they have gone soft on this issue. But if no action is initiated against Dr. Justice Ganguly, it will be a travesty of justice, and it will be a miscarriage of justice, if I may say so. The whole thing has, yes?
No, go ahead, sir.
The whole thing has brought the entire judiciary under a cloud, and people are saying that this girl had at least the courage to write on her blog, even if 1 year after the event. How many more cases of sexual harassment take place without anybody complaining? Nobody knows. So things should come out of the closet, and if exemplary action is taken in this case, I think it will clear the air for further skeletons to come out of the judicial cupboard.